so. Raise your hand. All right, for the record, my name is Richard Winegarden. I am a senior Superior Court judge. I was a Superior Court judge in Pickens County for 21 years. I am now a senior Superior Court judge. On June the 29th, 2016, I was assigned to handle this case, 2016 SUCR 274-P. And as I said, this is my second time ever in confines of Pickens County. And I want to put on the record that I came into the building about 10 minutes before 3. I was greeted by a deputy at the door. The deputy, I don't know his name, brought me upstairs. Outside the courtroom, I was met by another deputy who met me outside the courtroom, gave me a badge to get in the door, and I entered that way. So I say that because I don't want anybody thinking I've been here since 2 o'clock, sitting in the back here, doing anything. The only person I knew when I came into the courtroom was law clerk Cammie Fowler. I said, "Hi, Cammie." She says, "I can't talk to you." So other than the 2 sheriff's deputies, that's been my experience in this courtroom so far. Came out here, came in this room, haven't seen anybody other than that. I've been handed, and for the benefit of those that were downstairs prior to the media coming in, what I've done so far is introduce myself, asked who represented the state, found out Mr. Ray, Mr. Michael Ray. I inquired if Mr. Thomason was here. He is here, represented by Ashley Merchant. I inquired if Mr. Stookey was here. He's present, represented by Fletcher Griffin. Then I suggested that we bring the media in and deal with the media request for coverage. Has anything else transpired whatsoever in this courtroom since I took the bench other than what I've just delineated, Mr. Ray?
Hang on.
Mr. Merchant?
No, Judge.
Mr. Griffin?
Other than you received my notice for speedy trial on the president's document.
And I was going to correct myself, but you did it first. You did come up and place on the rail of the bench 2 documents. One's titled Notice of Appearance of Counsel. Second is entitled Motion for Speedy Trial under 17-7-170, both filed in today. So is today the first time you've entered an appearance of counsel in the case, Mr. Griffin?
That is correct, Your Honor.
And this happened at 1:52 this afternoon, correct?
Correct, Your Honor.
All right. Ms. Merchant, have you filed an entry of appearance in the case?
Judge, I have several filings that I might be filing depending on how today's hearing goes.
But have you filed an entry of appearance in the case?
No, Judge.
Okay. So officially, you haven't filed anything in the case making you the attorney of record for Mr. Thomason?
Just appearing before Your Honor. Officially.
But
as
you have
it's
not filed any document?
written, no.
Okay. So, is it fair to say that if I checked the clerk's file at 12 noon today, it would have shown neither Mr. Griffin nor Ms. Merchant represented these defendants? Is that correct, Mr. Griffin?
That's correct, Your
Correct, Ms.
Honor.
Merchant?
I believe so,
Okay.
yes, Judge.
Have you served the state, Mr. Griffin, with these 2 documents that you placed up here?
Yes, Your Honor.
Okay. All right. Mr. Ray, are you ready to proceed with the hearing on the motion for malpractice?
Yes, Your Honor.
Are you ready, Ms. Merchant?
Yes, Judge.
Are you ready, Mr. Griffin?
Yes, I am, Your Honor.
All right. I'm going to spend a few minutes, see, dealing with some issues that have arisen. And my decision to set down a hearing today has been questioned and criticized publicly. And I think it's important to address at this time, in this fashion, my reasons for doing what I've done. I've never done this before in my life. In 25 years on the bench, I've never explained why I set down a hearing, when I did, how I did it. But never before either, probably in the history of the state of Georgia, has there been so much attention to a motion for null process. And never have I had, well, I don't want to say never. And it's very unusual, in my judgment, for the court to be questioned or criticized for handling of a case prior to the court really doing anything in the case. And so therefore I want to address some issues. And hopefully after I get finished, those of you who are questioned or criticized the way I've handled things will understand. And I want to refer to a article that was online in the Daily Report last Friday, July 15th. I don't know if it appeared actually in the newspaper or not, but it was online. Got a picture of me. And it says as follows. I'll quote from most of it, a lot of it. It starts out by saying, the caption is, "Judge sets hearing rather than dismiss charges against publisher lawyer." And it starts out by saying, after sitting for a week on a prosecutor's, I'm going to start over since somebody cleared their throat. After sitting for a week on a prosecutor's motion to drop felony charges against the North Georgia publisher and his lawyer stemming from their efforts to obtain county bank records, the judge assigned the case has taken the rare step of setting a hearing instead of granting the request. On Thursday afternoon, and I'm quoting the article, Senior Judge Richard Winegarden informed lawyers for Mark Thomason, publisher of the Fannin Focus in Blue Ridge, and Hiawassee lawyer Russell Stookey, that he will hold a hearing Monday before deciding whether to dismiss an indictment charging both men with identity fraud and attempted identity fraud, and Thomason with making false statements to a public official. Lawyers for the two men confirmed Thursday. I assume that was you, Ms. Merchant, and Ms. Griffin that confirmed that. I assume it was you, even though you weren't officially in the case. Weingarten's decision came as a surprise to Thomason's defense attorney, Ashley Merchant, who said she has never been summoned to a hearing on a motion to now prosecute a criminal case. It was also a surprise to former DeKalb County prosecutor J. Tom Morgan, who was not involved in the case, but said he has never known a judge not to sign off on a prosecutor's motion to dismiss criminal charges. It goes on to say, Weingarten's decision not to dismiss the charges right away, despite the week-old motion to do so by Appalachian Circuit District Attorney Alison Sosebee, follows criticism by news media organizations that questioned whether the charges, which were prompted by the circuit's chief Superior Court judge, were warranted or even lawful. And then I quote, "Once the DA moved to dismiss it, that should have happened immediately." Augusta attorney David Hudson, longtime counsel for the Georgia Press Association, said Thursday. Speaking with the Daily Report Thursday morning, Weingarten declined to say why he had not signed the motion. "I don't think I should be talking to anyone about it," said Weingarten. "You should find out from someone involved in the case." Merchant told the Daily Report she had hoped the judge simply would sign the motion because under Georgia law, it would be easier to expunge Thomason's arrest from public records than if Merchant filed her own motion to dismiss the case. But Merchant heard nothing from the judge about his intentions until she emailed him Thursday afternoon to inquire about the status of the motion. Merchant called the judge's decision very, very unusual. Then she's quoted as saying, "I don't even know what he's going to do at the hearing," she said. "I've never had a hearing on a malprause." Stookey's defense attorney, Fletcher Griffin, declined to comment. Thank you, Mr. Griffin. Sosebee could not be reached. And then it goes on to say, quoting Mr. Morgan, the former DeKalb County prosecutor, Morgan said the judge's inaction, despite the prosecutor's motion, poses a dilemma. A judge can't make a prosecutor go to trial, nor can a judge force a prosecutor to go in detail about why he or she has moved to drop charges, he said. But a prosecutor can't make a judge malprose a case, he added. If it ends up in a stalemate, it technically remains an open charge. And there's more to the article, but I don't think it's relevant to my discussion here. As I said, I was assigned the case on June the 29th. Everything was quiet. On Thursday evening, July the 7th, so I want to get you you have an understanding why we're doing this hearing and why we're doing this hearing today, and why this inaction has occurred, and why I've been sitting on a case for a week. Thursday evening, July the 7th, I spent the night in Thomason, Georgia, prior to a bench trial calendar in Glascock County, which probably none of you ever heard of, scheduled for the morning of July the 8th. So the 7th of July, I was in Thomason, Georgia, getting ready for court the 8th of July. The next morning, got up, and the hotel provides a copy of the Augusta Chronicle newspaper. And page 2B of the Augusta Chronicle newspaper, the headline is, this is Friday, July the 8th. Charges to be dropped against newspaper publisher attorney. That's how I get my information. So I read that article, thought, okay, well, this is about over with. I presided in Glascock County until approximately 6 p.m. Friday. Drove home. The Atlanta Journal-Constitution was on the driveway, and there was an article about the case. Atlanta Journal-Constitution, Friday, July 8, 2016, which I first read the evening of July the 8th. It's entitled, Judge Seeks to End Case Against Publisher. There is a quotation in the, there's a paragraph in the article which says, Sosebee declined to comment Thursday because her motion had not yet been signed by a judge to make it official. Okay. Further on in the article, there's a quote attributed to the defendant, Mr. Stookey. It says, talking about the request of malpros, Stookey, however, was not satisfied. And I quote the quote in the newspaper. I want a trial. I want to get in a courtroom and make them prove this crap. Stookey said, they could come back in 6 months and do it again. I'll be known as the lawyer who did fraud and went to jail for it. I did no fraud, and I don't deserve that moniker on my reputation. So I'm reading that I've got a motion to malprosecute case, and I'm reading that one of the co-defendants does not want his case malprosecute. He wants a trial. on Friday, July the 8th. Next day was Saturday, obviously, July the 9th. And in the mail came a letter and a copy of the motion for Nalpros from the District Attorney, Alison Sosebee. Letter dated July the 7th, with the style of the case of Dear Judge Winegarden, pursuant to an order filed with the Clerk of Superior Court, you have been assigned to preside as the Superior Court judge in this action. Please find enclosed the motion to Nalpros, and I'm shortening the name Nalprosecui because I can't pronounce it. Nalpros this action. Then it says, upon your direction, I will prepare a rule nisi setting a date and time for this matter to be heard. Thank you for your assistance and attention to this matter. Sincerely, B. Alison Sosebee. So at this point, I've got a motion to Nalpros. I've got a defendant that doesn't want the case Nalpros. And I've got a district attorney that appears ready for me to have a hearing on the case. And she's going to do the rule nisi. Sunday, July the 10th, I took the day off. Monday morning, July the 11th, a week ago today, at a dentist appointment in Lilburn, Georgia, 11 o'clock. Prior to my dentist appointment, I'm not trying to give you my personal life, I'm just trying to explain what I was doing last week. Prior to my dentist appointment, I called the district attorney's office and was told that Ms. Sosebee was on vacation and unavailable. I left word for Brian Stanford, who this gentleman claims to be, who was chief of staff and who I thought was an attorney, to call me. Did not hear from Mr. Stanford on Monday. However, while sitting in the dentist chair, my phone started ringing. Not knowing it might be something important, I answered it, and it was somebody from an organization, which I won't mention, that said, I'm so-and-so with this organization, and I'm calling to suggest and encourage you to sign the Nalpros against Mark Thomason. I said, thank you for calling. I get back in the dentist chair. Phone rings again. Hello, I'm so-and-so with this same organization, and I'm calling to suggest that you sign the Nalpros against Mr. Thomason because he needs to get back to work. He needs to get this investigation going. And I said, well, thank you. The third call was from Indiana, and I didn't know anybody from Indiana, so I just took a message, but that was a regional director of this organization who left a message, which I still have on my phone, basically saying the same thing. It was a long message, encouraging me to not press the charges against Mr. Thomason. Later that day, I got a call from a professor here in Georgia saying, and I have his name, I want to encourage you to sign the Nalpros against Mr. Thomason. He needs to get back to work. See, I'm not like sitting judges that have an office and the staff and people to screen your calls. I have a cell phone. Anybody can go to a certain site on the internet, find my phone number in the state bar, and call me. So I don't have the screening process that most people have. So when my phone rings, I don't know what it is. So I answer the phone. So I asked and I'm not sure if it was this gentleman or one of the other people that called. I said, did somebody send out an email suggesting that everybody call the judge and given the judge's phone number and call the judge? He says, yes, as a matter of fact, that's what happened. I said, well, who was it? He said, well, I don't feel at liberty to tell you. So somebody sent out an email with my phone number and said, please call the judge and tell him to do such and such with this case. So let me ask this question to the lawyers that are at the table here. Is it ever, under any circumstances, appropriate for anyone to call a judge and encourage them to rule a certain way on a case? Mr. Ray.
Absolutely not.
Ms. Merchant.
Definitely not, Judge.
I beg your pardon?
Definitely not.
Mr. Griffin?
Never, Your Honor.
So we've got a lot of media people here So, you've just heard 3 lawyers tell you that it's never appropriate to call a judge and try to influence a decision on a case. Not to say you should never call a judge. I got calls last Friday while I was holding court in Clark County, people wanting to know where to send the Rule 22. I don't have a problem with that. Newspaper called me for when's this going to be scheduled, when's that going to be scheduled, different things. There are appropriate times to call a judge, ask questions. But it's never appropriate, in my judgment, and these 3 lawyers, to call a judge and try to encourage him to do something. If you think about it, if I'm a sitting judge and I have 300 cases, and 2 people from every case and every side of every case call me, how many phone calls is that? So don't call judges trying to influence their decision. All right. Unfortunately, I did not hear from back from the person I did want to talk to, Mr. Stanford. Tuesday morning, July the 12th, 6 days ago, I had an all-day divorce mediation that started at 10 o'clock in Alpharetta. It lasted all day. Before I went to the mediation, Tuesday morning, I got the AJC off my driveway, and there was an article. And the article said, drug tests continue for publisher and records case. There was a paragraph in the article which reads as follows, attributed to Mr. Stookey, saying that District Attorney Alison Sosebee, quote, couldn't convict Hitler, unquote. Stookey said, I want a trial. I want to get in a courtroom and make them prove this crap. I'm not going to live the rest of my life at the whim of those idiots. 2 paragraphs below, it says, a retired judge from Gwinnett County was assigned the case when all 3 judges in the Appalachian Circuit recused themselves from the case because of a potential conflict of interest. And now Ms. Merchant gets quoted. I'm a little surprised the order to drop the case hasn't been signed, said Thomason's criminal attorney, Ashley Merchant. Now this is in Tuesday morning's paper, so I assume that she spoke with the reporter on Monday. So I got the motion in the mail on Saturday, and on Monday, people are saying, why hasn't he signed this order yet? Well, first of all, there is no order. I think those of you familiar with the process understand that an order to now process is prepared by the state. Did your office ever send me an order to sign?
No, not to my knowledge.
No, okay. So when Alison Sosebee sends me the motion for now process, there's no order there for me to sign. There's a motion, and then there's a letter saying, if you want me to set down a hearing, let me know. So as of Monday, it's going to be very hard for me to get an order signed, delivered to Pickens County, filed in the clerk's office, and then they notify people, lawyers are not even in the case yet. We're not in the case, well, still aren't in the case. So I want you to contrast what I'm hearing. I'm seeing that one lawyer wants, one defendant wants a trial. A lawyer purporting to represent the other one says, why hasn't he signed the order yet? While driving to my mediation last Tuesday, I called and left word from Mr. Stanford. He did call me back in the middle of the mediation. He told me that as far as his knowledge, there was no entry of appearance for either defendant, which is apparently true. So I asked him to contact Ms. Merchant, who was quoted in the newspaper, to see if she did represent him, try to get some sort of a consent order on the motion for now process. I finished the mediation pretty late, went home. That's Tuesday. Wednesday morning, medical test starting at 10:30 in Johns Creek. Test lasted to 2:09. I had a habeas filed the week before, a criminal habeas in Forsyth County, which I agreed to hear, which had to be heard last week. So after I left the doctor's office at 2:09 last Wednesday, I went to Forsyth County, had a hearing at 4 o'clock. After that, I drove directly to Clark County because I was to preside there Thursday and Friday. While sitting in the doctor's office, I picked up the Johns Creek Herald, and thumbing through it, found on page 10 an article about this case, but with no criticism of the judge that I could tell. I'm not sure if it was Tuesday or Wednesday that I was advised that Mr. Stookey had done a lengthy radio interview in which he claimed to want a trial. Excuse me. So apparently he was going public on the radio telling everybody he wanted a trial. Still, I had no entry of appearance from any defense lawyer and no contact with anyone representing either the defendant about the now process whatsoever. So Thursday morning, July 14th, I was doing bench trials in Athens, Clark County, took a break, and the judges I was hearing a case for over there said she had heard about this case, and I told her I was trying to get something done, but I had nobody to talk to, I had no lawyers to talk to, the district attorney was out of town and unavailable, and I was reluctant to call two pro se defendants about this now process. One was saying he wanted a trial, the other one was, I don't know. So she said, well, if I can help you in any way, let me know. I said, well, let's set, I said, what I want to do is set down a hearing, this was Thursday, let's set down a hearing for Monday at 3 o'clock. Because I had a dentist appointment again today at 11, and it's at 3 o'clock. So she prepared a real nice on it for 3 o'clock today. I signed it, she faxed it to Pickens County, and they were instructed to serve the defendants. And round about that same time, I got an email from Ms. Merchant saying, I'm involved in this case. What are you gonna do about the, I don't want to say it with the wrong inflection. She said, not that there's inflection in death messages, but she said, I represent him. Can you please tell me what you're going to do with the motion and now process? And I texted her back saying it's set down for 3 o'clock Monday. There's been no entry of appearance from any lawyers, so I can't send copies to lawyers. So they're going to be notified directly. Friday, I presided in Clark County and came to the office, and the law clerk said, well, you should see what the daily report said about you today. That's the one about after sitting on the motion for a week, whatever. Article. So, what I was looking at was a case that was barely 2 weeks old, where the district attorney wants to now process it. I'm getting phone calls to grant the motion from the public. I had one defendant, one publicly stating on the radio and in the newspaper that he wanted a trial, did not want a now process. I had no lawyers to talk to. And so it seemed like a good thing to set up a hearing. And the earliest I could do it was today. So that's what I did. And I also want to say is that, when people, I didn't want to get in a situation where these people from this organization were calling me. A day later, I signed a now prof, and without being in open court. And then they said, hey, he wasn't doing anything. We called him, and something got done. So we're taking credit for the judge doing what he did. So, and I was concerned that, if I sign the now prof against both defendants, Mr. Stookey say, what's the deal here? What are you doing that for? I want a trial. If I didn't sign them, I'm in trouble. Either way, so let's have a hearing. But there's an even more compelling reason to have a hearing in open court. The law requires it. Code section 17-8-3, and I hope those in the media will make a note of it. Code section, Official Code of Georgia, annotated section 17-8-3, entitled Entry of Null Prosequi. Here's what it says. After an examination of the case in open court, and before it has been submitted to a jury, the prosecuting attorney may enter a null pros with the consent of the court. After the case has been submitted to a jury, a null pros shall not be entered except by the consent of the defendant. The first sentence is what's applicable. It says, quote, if you want me to read it slower so you can write it down, I will. It says, after an examination of the case in open court, and before it has been submitted to a jury, the prosecuting attorney may enter a null prosequi with the consent of the court. I want to call everybody's attention to the case in the Supreme Court of Georgia, Lewis versus the State, 101 Georgia 532, an 1897 case. It says, the object of section 957, which was the code section, that's how they numbered them back then apparently. The object of section 957 is to prevent entries of null pros by the Solicitor General without the sanction and approval of the judge, who presumably will not allow such entries to be made except for a good reason. An examination in open court is required in order that a judge may have proper and lawful information upon which to base his action. Also call your attention to the case of Thomason versus the State, 142 Georgia Appeals, page 888, decided in 1977. It says, Judge Marshall wrote this opinion, Code section 27-1801, they had changed the numbering system again, but it's the same code section. Code section 27-1801 provides in part, after an examination of the case in open court and before it has been submitted to the jury, the district attorney or solicitor may enter a null pros with the consent of the court. The requirement that the null pros be entered after an examination of the case in open court would appear to be for the purpose of protecting the interests of both the accused and the state by making all the proceedings be conducted openly in the courtroom, in the presence of the judge, the prosecutor, the accused, defense counsel, and anyone else who legitimately may be present, rather than covertly, clandestinely, and behind the scenes, so as to conceal or at least give the appearance of concealing the fact and the true purposes of such proceedings. This principle has its roots in historical revulsion toward and reaction to the ill-famed Star Chamber of antiquity, in which the accused was little more than a pawn in the hands of the realm, which could arbitrarily and privately strip him of his life, liberty, and possessions. Also cite the case of La Rochelle, L-A-R-O-C-H-E-L-L-E versus the state, 219 Georgia Appeals, 792 and 1996 case. It says, OCGA, now we got our system of numbering. Section 17-8-3 allows the prosecuting attorney to enter a null pros with the court's consent before the case has been submitted to a jury, but it requires an examination of the case in open court. After the case has been submitted to the jury, a now pros shall not be entered except by consent of the defendant. So that is why I chose to have a hearing in open court today. 7 business days after Ms. after Ms. Sosebee filed a now pros. 7 business days after she filed the motion for now pros, we are having a hearing in open court. Now, let me also say that in agreeing with the comment that Ms. Merchant said, is that she doesn't think, or far she's never been summoned to court on a real nice side for a now pros. I agree, it's unusual. Usually, the defendants want their case dismissed. Typically, if a defense lawyer can get the district attorney to agree to dismiss their client's case, it's a victory. They are elated, they celebrate. Okay? But that wasn't the case in this situation. So very often, what happens in cases is that typically the way these cases, somebody gets arrested, they get a lawyer, time goes by. They get indicted, time goes by. They get arraigned, time goes by. And over months or years, the defense lawyer and the district attorney's office will talk about the case. If all goes well for the defendant, the DA will eventually agree to now prosecute the case. That usually takes a long, long time and a lot of work by the defense lawyer. Here, the case was dismissed, or now process was entered on the 7th for an indictment returned on June 24th without any lawyers even being involved in the case. There was no lawyers involved in the case. No lawyers negotiated, as far as I know, negotiated this outcome of the case. So, typically, in my experience, that I'd be in the bench in my home circuit, and a DA from my home circuit would bring me a case from my home circuit and say, Judge, we want to now process this case. Well, what's the defense lawyer said? Oh, they're excited. They're delighted. And it's done in open court. It's signed. It's done. You don't have to have a hearing. Because most defense lawyers don't want to be brought to court with their client to get their okay to dismiss the case. But that's a different case than what we have here. So, is it unusual to have a case set down for a hearing on a motion for an outcross? Yes. Was it necessary in this case? In my judgment, yes, it does. Because if you think about it, if I had signed some sort of order last week, what would have been written about it? So, briefly, that's what I have to say. Are you ready to proceed with your motion, Mr. Ray?
Yes.
Are you ready to proceed on this motion, Ms. Merchant?
Yes, sir.
Mr. Griffin?
To the extent we're willing to participate, yes, Your Honor.
To the extent you're willing to participate?
Yes, Your Honor, if I'd like to state for the record,
I'm having a little trouble hearing you.
I defer to the court. The court decides the law is that Mr. Stookey's objection or consent is not an issue under that statute, that it purely a matter between the state and the court as to whether it's granted or not. Of course, we object, and then we'd like to see justice go forward and get a speedy trial and what have you. But I'm not sure that we have standing to actually participate in this process, Your Honor, other than we're just a named defendant.
Well,
and I refer to the Lehman case and the Lejeune case and a few other cases I'm sure Your Honor is aware of and will be aware of.
see, obviously, I don't base rulings based on what I read in the newspaper. And I mean, and you know, so I don't know until I get here what your position is, and I don't know what her position is, and so that's what I'm trying to find out.
We just wanted to clarify the record. Mr. Stookey is not consenting to the law process, Your Honor.
Okay.
But I'm not sure what our legal standing is to object at this stage of the proceedings.
Mr. Ray,
Yes,
what do you want to say, if anything, in support of your motion to outcross cases about against both defendants, assuming you still want to?
Yes, sir. First off, I would say that as to what Mr. Griffin was saying, that they lack standing in order to object to the motion to non-cross, I would agree with that. The court, I'm sure, has looked at 1783. The second sentence starts off, the prosecuting attorney shall notify the defendant and the defendant's attorney of record within 30 days of the entry of a non-cross, either personally or in writing. It would be the state's position that the entry of the non-cross is the actual non-cross itself, the order that's signed by the court. The requirement being, with the first paragraph under 1783, is that it be an open court, which we're here today. We have got a bailiff, we've got a clerk, we've got a judge, we have a state, we have defendants. That is open court. Ms. Sosebee, who also wanted me to inform the court that she was going to handle this hearing herself, but she is out of state on a pre-planned vacation, and I believe she's actually still in London today. She filed the motion to null cross, and as the court said earlier, sent a copy. The motion states that the victim set forth in the indictment has made a written request that this case be dismissed, and a copy of said request is attached here too as Exhibit A, and I believe it has been filed with the clerk, and I believe the judge has also provided a copy with that, and based in the victim's request in the interest of justice, we are moving to dismiss it. The last point would be that, Your Honor, under 1717-11, the victim in a criminal case has the right to express their opinion as to the disposition of the case. So the state's motion is that based upon the victim's request that it be dismissed, the district attorney, Ms. Sosebee, has taken that into the consideration and would submit that the court enter a null cross in 2016 CR 274 as to all of the accounts contained in the document.
Ms. Merchant, the state wants to now cross the case against your client, Mr. Thomason. Your position?
We agree that we don't have any standing to object. We would not be objecting anyway, but we agree we don't have any
Well,
standing.
I think I don't know that you don't have standing to object. I think you can object. I think why even have you here if you can't object? I think you can object.
I agree, it's confusing, and I looked at the case law to see, and it appears, I did find a case that says specifically that we have no right to object on the first bill of indictment unless it had been entered without his consent. It's an 1886 case. It's still good law, but that's the only case I could find on point. Regardless of that, we are not objecting. So that's not something, luckily, that we have to reach today.
And you agree, this is like a dream come true for criminal defense lawyers in most cases.
It is definitely our goal because it's the most readily expungible. It's what we want. We want a decision from the state saying that they're not prosecuting.
So you're happy about
Yes.
their decision
Very much so.
to not prosecute.
Yes.
You want me to not prosecute
Yes, please, Judge.
against your client?
Yes.
Your Honor, I already have a proposal we're prepared.
All right, let me see an order on Mr. Thomason, please.
Madam President.
Yes. And those of you that have looked at the law, I assume will agree that within my discretion to grant it or deny it.
That's correct.
Either way,
Yes.
no matter what you say, as long as I've got a motion here before the jury's and panel, it's in my discretion to grant it or deny it.
Absolutely.
That's absolutely correct.
And we agree that's the law, Your Honor.
Okay. I've just signed an order which says State of Georgia versus Mark Brandon Thomason, defendant, case number 2016 SUCR 274, now process order. The above style case came before the court July 18, 2016, and after examination of the above style case in open court pursuant to OCGA section 17-8-3, The court hereby accepts the state's recommendation for an order of now pros as to count 1, identity fraud, count 2, attempted identity fraud, and count 3, making a false statement. So order this 18th day of July, 2016, signed Richard T. Winegarden, Superior Court, Senior Judge, State of Georgia. Shall I give this to the clerk in her file and provide you with copies?
That's fine.
Your client's case has been now pros.
Thank you, Judge.
Anything else?
No, Judge.
Okay.
Would you like us to stay here or be excused to the courtroom, to the gallery?
I don't want you to leave,
But we can stay here
but
wherever
you
you'd like us.
could find a different location in the courtroom, but I would like to speak
Yes.
to you and counsel
Definitely.
at the end of the proceeding,
Okay.
if you don't mind doing that.
Would you prefer us to sit in the courtroom or here?
Doesn't matter to me.
Okay.
Your case is over.
Thank you.
All right. Mr. Griffin.
Yes, Your Honor, and I agree with Mr. Ray that the defendant's consent or objection in this matter really doesn't go to whether the court can do under its discretion what it wants to do, whether they need to consider the defendant's objections. And obviously, Mr. Stookey is worried, has anxiety, his reputation has been smeared, if you have it. He still is in jeopardy.
Let me interrupt you a minute.
Yes.
Would you mind stepping up to the microphone and
I'd be
making it
happy
work
to, Your Honor.
so I can hear you better?
No, where the defense is coming from, the only case I could find was back in 1970. Basically, the defendant still remains in jeopardy. The state is not prohibited from coming back within 6 months and bringing a new indictment against Mr. Stookey. Now, I hope to have cured that by filing the speedy demand, but if the court goes ahead and grants the null pros, then that's giving the state another 6 months to put Mr. Stookey through the anxiety and embarrassment and humiliation and damage to his reputation. And what in fact constitutes a proper showing by the state to satisfy the court to exercise its discretion. I couldn't find any case law, Your Honor, but I can say this, that if in fact the court refused to grant the motion for null pros, I anticipate the state has a right to appeal that decision, still leaving Mr. Stookey in jeopardy. There's a case.
I don't think they can make me sign it. I don't think they can make me not prosecute.
No, we can't make them do it. I mean, all they can do is bring the motion in the court here and grant it. But what I'd like to hear from Mr. Ray is this: let's go ahead and get to the finality of this matter. Let's go ahead and not only quash the indictment, let's go ahead and, before it's quashed, let's go ahead and have an entry of acquittal based on a motion by the defendant to the court and put this thing to bed once and for all. And that's what I'd ask Mr. Ray to consider, such that we can get through all these hoops and what have you, and Mr. Stookey can go back to his law practice and career without the smear or the taint to him. If that's the ultimate goal in this, is not to delay justice and to actually formally dismiss these charges with no intent of bringing them back, let's jump to that next hurdle and let's go ahead and consent to a motion of acquittal.
Do you understand what he's suggesting, Mr. Ray?
Yes, I am, Your Honor.
Do you care to respond?
Wait, we're not here today on a motion for acquittal or a motion to quash. I would say to Mr. Griffin and the court that even if the court did quash the indictment, with the state could actually also want to quash as long as it's within the statute of limitations, bring back a subsequent indictment with the same exact charges. Under the case law, it is essentially 100% in the court's discretion to accept the state's recommendation to null. As I said earlier, the attached Exhibit A, the letter from the victim in the case, Brenda S. Weaver, it's about two pages long. Ms. Weaver put in a lot of detail as to her reasons as to why she wanted the case non-pros, and actually went into enough detail as to count 1 and counts 1, 2, and 3, as to her specific reasons wanting it to be non-pros. Apparently, she had spoken to the district attorney, and the district attorney has accepted her expressed opinion, of which she has the absolute right to give. Yet again, under 1717-11, she has the option to be heard as to what the disposition is. So the state would request that the court rule on the motion to non-pros as to Mr. Stookey, and ask that you grant the motion to non-pros.
In response, his response, Mr. Griffin?
No, Your Honor, I think I've said what I'm allowed to say, and we certainly submit the question to the court.
You can say whatever you want to.
No, I understand. I know the court's not cutting me off, Your Honor. I think the court has the discretion to do whatever they're going to do today, and then we'll take that step.
I'm a little bit confused. No, I don't want to be confused. I'm a little bit unsure as to your client's desires and your client's intentions, in the sense that he's been quoted in the newspaper saying he wanted to stay in court. And now you seem to be saying, no, he doesn't want to stay in court. He wants these charges to go away and never have to be in court again. So I'm not sure whether he wants to have a trial, have a day in court, and try to prove his innocence, quote unquote, or he wants some finality and not to have to face these charges anymore. Do you understand what I'm saying?
I do understand
If you come up
what
to the
you're
podium, you don't.
Yes. Your Honor, we both know, or everyone should know, that having on your criminal record a motion to non-pros versus the benefit of a acquittal is two different things. For the benefit of expungements, for the benefit of a finality, that's the most preferred route. So we have no hesitancy, subject to our demurs to the perfectness of the indictment, and getting this thing home for trial and let 12 citizens, hopefully and expectedly, exonerate us. And that gives this defendant his right to his day in court.
So
The non-pros is not going to give us any right to our day in court.
So do you want the charges to go away forever, or do you want your day in court?
We prefer to have our day in court, Your Honor. If the court feels that they can grant that kind of relief.
You just indicated that there's a difference between an acquittal and a
A
non-pros.
grant and non-pros are two different things.
There's also a big difference between a conviction and a non-pros.
We understand that, Your Honor.
You've practiced law a long time, because I've watched you practice law
Yes,
for
sir.
a long time. You've handled a lot of criminal cases, correct?
Yes, sir. And this is the first time I've ever argued against a non-pros. The court was very
Have you
active
ever
in
seen
that
anybody
statement.
argue against a non-pros?
Not in my career, Your Honor. And I started out in '78.
And your client's a lawyer.
Mike Lawrence, a lawyer, yes, Your Honor.
So the
He's also
first-
my client in the citizen and has constitutional rights of due process.
So the first person you know of, only person you know of that's argued, that wanted you to argue, or anybody to argue against a non-pros is your client, the lawyer.
At this time, yes, Your Honor.
I'm not entirely sure, but I'm guessing that a conviction for a felony has an effect on a bar license.
It would disbar him, Your Honor.
So, if he goes to trial
Lose.
and is convicted, he's going to be, you're already saying he'll be disbarred?
It'd be disbarred, Your Honor. That is a crime of moral turpitude is alleged in the indictment. If it fact the indictment alleges a crime, then that would be a crime of moral turpitude. That's the ultimate sanction on that is disbarment.
That kind of put a lot of pressure on you, Mr. Griffin?
No, sir, I'm prepared and ready. I go to trial today to get the jurors that are in this courthouse here, Your Honor. They're in here.
I hadn't planned to spend the night.
No, sir, I know you did.
And you've seen enough trials with enough juries to know that jurors don't do what you expected.
I agree, Your Honor.
And you don't know what a jury's gonna do. Is that a fair thing?
I have absolutely what 6 or 12 people do. It amazes me every day, Your Honor.
So rather than accept the state's non-pros, he wants to have a day in court, take a chance of being convicted and being disbarred.
Well, that's our risk, Your Honor. And in a matter of justice and decency, Mr. Stookey, he wants that opportunity.
And I ask this question because I don't know the answer. What effect does the pending indictment have on his practice of law?
Sir, I'm sorry.
Sorry. I'm asking this question because I don't know the answer. What effect does a pending indictment have on his practice of law?
Should have none.
I mean, is there any restrictions or any complications?
Well, yes, there are right now. For example, the indictment stays in the present form and the bond conditions stay in their present form. This man can't even go to the courthouse in this circuit if, in fact, any of the witnesses that were listed are anywhere within a spitting distance. So his practice of law is being interfered with as we speak. His contractual obligations to his clients are being interfered with.
Which would go away if the case was not processed.
Well, those bond
Case is not
conditions
processed.
would be lifted if they're not processed, Your Honor. But right now, he is restricted in being able, he's got cases in the circuit from really appearing on behalf of his clients without violating his bond condition. We need some finality and termination to this case. And maybe the state, an additional thought, may agree that maybe this thing would be right for a motion of acquittal as opposed to just a motion to non-profit. If that's their intent. If their intent is just to dismiss it and try to get it perfected a little better and delayed, you know, that's certainly their right and their strategy. There's a case, the Lehman case, where the poor guy got indicted 3 times. It was in the middle of a trial, or even after the trial, they went ahead and did another motion to quash, and the court held, or the appellate court held, he wasn't entitled to double jeopardy because the other 2 previous indictments were still pending. And that basically it operated to allow the state to keep this poor case hanging over this man's head for years and years. And so the court, I can give the court the side on the Lehman case.
Let me back up a bit. Let's forget about the bond.
Okay.
The bond condition. Just the indictment itself. Does that affect his practice of law? Is there any restriction? I mean, does the bar do anything about that? I mean, you can be under indictment and still practice law. It doesn't matter. They don't do
I don't know of any impairment while he's subject to indictment, Your Honor, that the state bar will impair him from practicing law.
So a lawyer.
Only the bond condition is the restriction.
So a lawyer could be indicted for a crime.
Yes.
And still practice law.
My understanding is that happens every day, Your Honor. Maybe I'm wrong, but
I don't know. I don't know the answer.
Mr. Stookey was on the disciplinary panel for the state bar that he says he can still practice law.
As an experienced trial lawyer, Mr. Griffin,
Yes, sir.
based upon what you know about this case and the circumstances, what do you think is the likelihood that the state will try to re-indict Mr. Stookey if this case is not brought?
I don't think they will under his present form, Your Honor, or try to go back in his present form. They may try to do something different. And I hope if the indictment's still left intact, then it'll become a moot issue at the end of the second term under our speedy trial demand. And we do have a right to ask for acquittal at the end of the second term, which should end in February. Not 6 months from here.
Yes,
I'm curious as to when this trial has, when the case has to be tried under the speedy trial.
Well, right now, they're jury present. I'm counting that as our first term, so we take 6 months from the end of this term, which will be, when does March term end?
Should go to
Probably
September to March.
And then count 6 months from September. And then it becomes I would hope it becomes a moot issue.
So-
Bring the motion.
So the case is not now processed.
If the case is not now processed, they don't bring it back up, and they don't bring him to trial, and if in fact we now run the first term, we only have one more 6-month term to run, which would be sometime in the end of February, I guess.
Now, my understanding is that on a motion for, on the demand, you have a year from the filing of it, within that term or the subsequent term.
That's correct. They have 2 terms, and we're in a present term.
So even with a speedy trial demand, if the case remains pending, they don't have to try him in July, they don't have to try him in August,
No.
they don't have to try him in September, they don't have to try him in October, they don't have to try him in November, December, January. If they don't get it by February or so, then he gets acquitted.
That's my
In the meantime, he
understanding.
wants these charges to remain
That's what I'll
pending.
be arguing, Your Honor, and that's my understanding.
He wants these charges to remain pending instead of being over with today.
Well, they would not remain pending, get us to trial. Let's go ahead and lay it out.
Yeah, I was just wondering, I mean, I'm sure the court knows that he hasn't been arraigned yet, and
No,
they
he knows.
also, a lot of things the court was inquiring about, and if it did go to trial, that they hadn't even received any type of discovery.
We have discovery, demurs, and a lot of pretrial things that need to be argued to get it
I
to
only
the
got
trial.
one interior appearance so far.
That was another thing.
Of course, I only got one defendant now. That's right.
Well, if we submit it to the court, Your Honor, we certainly honor the bill. You have to say in the matter, and we'll pass by saying, if we don't have a right to appeal a denial or grant of this motion based on my research. They do, we don't.
I don't know that they do.
I've never seen it done.
Mr. Ray.
No, it has been done, Your Honor. There is a case where the state appealed a grant of non-right. I read it
The
this week.
state, well, I think some of the cases get involved where there's a re-indictment in the trial, and the jury's impaneled or not impaneled, that sort of thing. So we don't have the jury impaneled in this case, that's for sure.
No, sir.
Mr. Ray, you are assistant returning in what circuit?
That left, sir.
And how many counties does that handle?
Pickens, Gilmer, and Fannin.
How many lawyers are in your office?
In Pickens County,
No, I mean in the circuit.
8,
8.
with 1 being juvenile, I think.
Do you have many cases?
I believe there's still good. I have cases in all 3 counties.
Is your office busy?
Pardon?
Is your office busy?
Yes. So, we're still a small circuit, but especially Pickens County contains about 50% of all cases. Like for an example, a month ago, in April, we tried armed robbery. And that took a week. So we were, especially because here jail cases go first because they're in custody, and currently we do have a lot of those. If I may just make one more thing, Mr. Stookey is wanting some finality. I mean, the null process gives him finality. It allows the bond conditions are extinguished upon your signature and the filing of it. He would be able to go back to his practice, go to the courthouse, he could go wherever he needed to go. So I think that alleviates that concern. If the concern is that it's going to be re-indicted at some point, I don't think that the district attorney would file a motion stating that the victim doesn't want it prosecuted, only to turn around and re-indict it a week or about 10 days after filing the motion.
Has your office got other cases to handle?
Yes, sir.
Have you got other victims to deal with, or have you got victims to deal with?
Can I make a statement?
Yes.
When you sent to Will Nassau, my office was preparing and are currently in jury selection is where I've been this morning in a rape and aggravated child molestation case.
So you need to be doing things like that?
That's what I was doing this morning. I came over here.
Do you want to prosecute Mr. Stookey?
No, I have a null process Right.
Does your office have any interest in prosecuting Mr. Stookey at this time?
No, Your Honor.
Do you anticipate that you'll ever have any interest in prosecuting Mr. Stookey for the charges in this indictment?
I have not spoken to the district attorney about that, but I will say that I do not believe he has any intentions on reindicting the case.
Let me see your order. I don't think I am giving anybody any new information by saying there's a lot of crime around. And I suspect the district attorney's office is busy. And I suspect the court system is busy. And in spite of Mr. Stookey's desire to have his day in court, I understand having your day in court as opposed to settling a case, or I don't want to settle a case, a civil case, but I don't think it's a stretch to say it's virtually unheard of for a defendant to oppose a motion for non-profit. It's virtually unheard of for a person who's charged with a crime not to want the charges dismissed. And Mr. Stookey is certainly entitled to his position. But it seems to me that the resources of Pickens County are better served by prosecuting others rather than Mr. Stookey, especially in light of the fact that the state does not want to prosecute Mr. Stookey. And I can't, at this point, I can't control what happens down the road. I can't imagine that they will re-indict Mr. Stookey on these charges. So I think in that sense, if Mr. Stookey wants this case over with and done with and not have to worry about restrictions in dealing with this case, I think the best way to accommodate Mr. Stookey's desire to have this over with, even though he wants to do it his way, is to do it this way with the entry of a non-profit. So, in spite of the defendant's objection, I'm going to now cross the case against Russell Stookey. I've signed an order which says, in the Superior Court of Pickens County, State of Georgia versus Russell Stookey, defendant, case number 2016 SU-CR 274, now cross border. Above style case came before the court July 18, 2016, and after examination of the above style case in open court, which I think we really did, pursuant to OCGA section 17-8-3, the court hereby accepts the state recommendation for an order of now process to count 1, identity fraud, and count 2, attempted identity fraud. Is so ordered 18th day of July 2016. Richard T. Winegarden, Superior Court, Senior Judge, State of Georgia. That's how I do business. Anything else you want to put on the record in this case, Mr. Ray?
No,
Mr. Beg your pardon, Ms. Merchant?
No, Judge.
I'm sorry, you're not here anymore.
We're not
Mr.
here.
Griffin?
No, Your Honor. Does the court still wish to see counsel after the hearing?
I do. So, okay, anything else? All right, this matter is concluded. Thank you, ladies and gentlemen. Thank you for your patience. Thank you for your courtesy.
Thank you, Your Honor.
Thank you.